right. Mr. Goldstein, I do have your client, Mr. Cornett. All right, and grab his file. Good morning.
Morning,
Mr. Cornett, if you could start your video and your audio, please. Thank you. This is, it's okay. This is in the matter of the people of the state of Michigan versus David Brian Cornett. We have two files, 21-20415FH and 21-20414FH. I have David Goldstein appearing on behalf of Mr. Cornett. This is the time set for a pretrial on both of these files for a violation of probation. It has been adjourned, evidently, Mr. Goldstein, because of the charges in Downriver. So could you give us an update on what is going on?
Actually, Your Honor, the case arose downriver. It is right now set for trial in the Wayne County Circuit Court for the 17th of this month.
All right. Who's your judge?
Cox, Kiefer Cox.
Okay. All right. So, Mr. Goldstein, Miss Adams, I do not have a pink sheet.
Sorry,
I stole the docket from you before you were able to attach it. So hold on one second. So do we want to set a date after the first of the year, Mr. Goldstein?
Well, Your Honor, I'm assuming we want to see what's going to happen at the trial. We can do it in December or January, whichever the court prefers.
Okay, I didn't know what your schedule would be like.
Well, I have a pretrial in front of you on the 10th.
December 10th?
Yes, Your Honor.
Miss Adams, can I use that day?
Yes, that's a good date.
All right, so we will set it for pretrial on December 10 at 8:15 in the morning. Because it's a violation of probation, we will do the notice of hearing and we'll see back on that day, Mr. Goldstein. And I believe, so Mr. Cornett, you're all set. We'll see back on December 10 at 8:15 in the morning, okay?
Yes, Your Honor. Thank you very much.
Thank you, Your Honor.
Thank you. And then, Mr. Goldstein, I also have you representing Mr. Rosenberg. And
Yes,
let me
Your Honor,
see if he's
logging. No, I don't think he's on yet. I just sent him the Zoom ID about 2 minutes ago. So
somebody popped in on a Samsung. So let's see who it is.
oh, I see. Okay, yeah, it could be him.
All right, I have somebody on a Samsung device. Could you start your audio and your video, please? Send them a request. Hi, I'm the Samsung. What's your name, please?
Zachary Rosenberg.
Yeah. All right, Mr. Rosenberg. I don't know if you're able. Oh, there you
It
go.
goes. I kept clicking it. It wouldn't let me.
It's okay.
Join.
It's okay. You're good. You're good. All right. This is in the matter of. Let me find your file. Here we go. People of the state of Michigan versus Zachary David Rosenberg, file number 23-21322FC. I have David Goldstein appearing on behalf of Mr. Rosenberg. This is a probation violation, pretrial, and contempt. I do have a letter dated November 3rd of 2025 from Darren Coast, my pretrial services coordinator. He said that Mr. Rosenberg has done better as of late. He is actively being monitored by GPS tether with no additional violations since he left the state back on September 15. In addition, he is not missing with his testing and is now only testing positive for THC, and he does have a medical marijuana card. So, Mr. Goldstein, you're still on this case, so how would you like to proceed?
Well, Your Honor, I think with regard to the violation, not the contempt, with regard to the violation, there are matters still pending in the district court. So we'd like to adjourn this out a little ways. And I'll leave it to Mr. Coast what he wants to do about the bond violations. that's gonna be
Mr.
about
Coast,
the-
are you okay adjourning that out as long as he's in compliance?
Absolutely, Judge. He's done much better, so I'm fine with that.
Okay, Mr. Goldstein, I don't know the dates for any of your district court matters, but is December 10 too far out or not soon enough?
Not enough, Your Honor. Early January. I don't think his prelim in the case down below is scheduled until sometime late in November or early December. So probably sometime early January.
All right, how about January 7 at 8:30?
That would work.
All right, we'll set this for January 7 at, you want 8:15 or 8:30, Mr. Goldstein? You're always
It
here.
doesn't matter. 8:15 is fine, Your Honor.
Okay, I'll set it for January 7 at 8:15. Obviously, Mr. Rosenberg, you need to stay in compliance with all your conditions of probation and bond. And we will see you back on that day. Thank you. And Mr. Goldstein,
Your
I
Honor.
think that's all I had with you.
That's correct, Your Honor. Thank you.
Thank you. Have a good day. In the matter of the people of the state of Michigan versus Jonathan Paulding, both files arraignment was waived. It's not quite, is Mr. Iagully here? Mr. Garza is here. Mr. Murphy, I do have Richard Garza.
Your Honor, could I speak to him? If he could go out in the hallway, maybe?
All right, so Mr. Garza, yep, and then my bailiff can help you connect there. Mr. Malaro, I do have Chad Stewart.
Okay, Judge.
Who's this? She'll hook you up inside.
Oh, okay.
It's just another turn.
I was gonna
All
say,
right, I'm gonna send you a request to start your video. Mr. Garza, go ahead and click on that.
okay,
Yes.
Excellent. All right, so I'm gonna open up a breakout room and put you and Mr. Murphy in it. Mr. Garza, when you are done, just don't even disconnect, just come back in the courtroom, all right?
just go straight back in.
Yeah,
Okay.
when you're done talking to the attorney.
Okay,
Thank you.
all right, go ahead and click on join that breakout room. All right, so in the matter of the people of the state of Michigan versus Chad Stewart, we have two files, 25-22167 FH and 25-22168 FH. Mr. Stewart, I'm going to ask you, there you go. Thank you, Mr. Stewart. All right, I have Salvatore Malaro appearing on behalf of Mr. Stewart and Isaac Sneed appearing on behalf of the people. So this is the date and time set for a pretrial conference in this matter. I do have a letter from Darren Coast, the pretrial services coordinator. It said Mr. Stewart continues to do well with his testing. He never misses and is always completely negative. So, Mr. Malaro, how do you wish to proceed today on behalf of Mr. Stewart?
Judge, I'd ask to adjourn the matter. Our notes say that on October 8th, we sent a letter for him, Mr. Stewart, to be screened for drug court. We do not know the result of that. So that's the basis for my request.
All right, we have recovery court. We don't call it drug court anymore, but it's recovery court. We have a meeting tomorrow. So I can set this for November 26th at 8:30 in the morning. Can you do the stip in order to adjourn?
Yes, Your Honor.
Mr. Sneed, can you sign your name with permission?
Yes, thank you.
All right, excellent. All right, you're all set, Mr. Stewart, November 26th at 8:30 in the morning.
Thank you.
All right, thank you. Yeah, come back up here. And we are back on the record in the matter of the people of the state of Michigan versus Richard Perry Garza. I have Matthew Murphy appearing on behalf of Mr. Garza, and I have Alexander Bayanetto appearing on behalf of the people. This is your file, Mr. Bayanetto?
It is, Your Honor, yes.
Okay, good. All right, so Mr. Murphy, how would you like to proceed today with Mr. Garza?
Your Honor, we had a motion to from the people to consolidate with another file that was in front of Judge Olsaver. That wasn't granted, and I believe that other person, the other file, the co-defendant had pled. Mr. Bayanetto and I haven't discussed anything since that plea had been done on the other file, the co-defendant. I was going to ask for another pretrial in this matter to see if a discussion can be had about this case, or if Mr. Bayanetto wanted to set it for trial, I guess. But again, my thought would be another pretrial because we haven't had discussions about it.
Okay. December 3rd at 8:30 in the morning?
Your Honor, could we do it 1 week after that, please?
December 10 at 8:30 in the morning?
If that works for the people.
That works. Yeah.
Miss Adams, Mr. Garza is present in person. Could I get a notice of hearing for him?
Yes.
Thank
All
you.
right, thank you. All right, Mr. Garza, have a seat right behind you. And then my assistant will bring you a notice of hearing, okay?
Mr. Garza, I'll reach out to you in a couple of weeks, okay?
Yeah.
Thank you.
And you make sure you reach out to him too, okay? All right. Angelo Iagulli? Angelo Iagulli, you. Calvin Isom? Mr. Isom, you want to come on up? Mr. Sala. Matthew Ann's, all right. Is he here in person, Mr. Sala?
He's here.
Okay.
I went to my office to get the.
Okay, so this is in the matter of the people of the state of Michigan versus Calvin Tyler Isom, file number 25-22411FH. I have Matthew Murphy appearing on behalf of Mr. Isom. Is this also your file, Mr. Bayanetto?
It is, Your Honor.
Okay, this is the date and time set for a pretrial, and there is contempt of court violation that followed you up from district court. So, Mr. Murphy, how do you wish to proceed today with Mr. Isom?
Your Honor, Mr. Isom has sentencing, I believe, on November 14th for another file. I believe this file was supposed to be dealt with along with that plea. If I'm not mistaken on that, I guess Mr. Bayanetto can correct me, but I was going to ask if we could set this for, again, December 12th or whatever fits the court schedule best after that sentencing date, and then go forward.
What is supposed to be dealt with the other files?
I thought this was being dismissed with a plea on the other file
Okay.
that Mr. Isom had.
Mr. Bayanetto?
That's correct. That's correct,
All
Your
right.
Honor. Yes.
Okay, so November 12th is sentencing, Mr. Murphy?
November 14th, Your Honor, from
Oh,
my
November 14th. So I will set this over to November 14 at 8:15 in the morning with your sentencing, okay? All right, so, Mr. Isom, you are all set.
Thank you.
All right, and you've gone and done your pre-sentence report and you're good to go for sentencing?
I'm pretty sure, yes, ma'am.
Did you meet with the probation department?
Yes.
Okay, perfect. All right, we'll see you back November 14 at 8:15 in the morning. Thank you, Mr. Isom.
Thank you.
Mr. Murphy, can you do this step in order to adjourn?
Yes, Your Honor.
Okay, thank you. Okay, so. Mr. Murphy, I do believe that is all that I had with you, correct?
That's correct, Your Honor. That's all that I had down in my docket. Thank you, Your Honor.
Thank
Everyone have a
you.
good day. Thank you.
You too. Angelo Iagulli? Anybody? No?
Judge,
Mr.
if I may,
Malaro?
Mr. Iaguli.
What
He
about
always
him?
shows up for court. I've put out a message for him to come to your court. He may think he's due in district court, so if you
Okay,
could give us a minute.
yep, that's fine, because that's all I have left with you. Let's see. Mr. Sala, when your client gets here, I'll take yours. And Timothy Neves is in jail, so let me call the jail and get him. Mr. Amadeo. Your client's with me too, so I'll take you next.
Thank you, Judge.
Morning, Your Honor.
Hi, this is Judge Anselm. So I'm ready on Timothy Neves.
Yes, ma'am, I can get right in front of you.
And then I have Maria Rodriguez down, but she's probably on the first floor, so.
Yes, ma'am, she is.
All right, thank you.
Thank you.
Bye.
Bye-bye.
All right, Ms. Moran. This is in the matter of the people of the state of Michigan versus Jessica Lynn Moran. Just throwing files around. Okay. We have three files, 25-22303FH, 25-22304FH, and 25-22305FH. I have William Amadeo appearing on behalf of Ms. Moran, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for a pretrial conference, and I do have a couple things. I have a plea agreement form that states that a plea offer has been proffered that Ms. Moran would plead to count one on file number 25-22305FH, embezzlement 20,000 to 50,000. Let me get the right file. Okay, let me get back there. Which carries a maximum penalty of up to 10 years in prison. And then she would plead to an added count to embezzlement. Is that correct, Mr. Sneed?
The plea agreement I have shows in paragraph 2, added count 2 of embezzlement. So yes, Judge.
Okay, and then any habitual offender notice would be dismissed at the time of sentencing. There is a Killebrew agreement between the prosecutor's office and defense counsel that there would be no initial incarceration. The other two files would be dismissed, as I said, along with the habitual offender. Restitution will be in the amount of $39,000 to Premier Bank, $5,055 to the Kiwanis Club of Morenci, and $2,764 to the Morenci School PTO. Count one is to be entered as a deferred judgment of guilt. Defendant is to pay restitution in full and successfully complete probation. Otherwise, deferral status will be revoked and a judgment of guilt entered. But the deferral doesn't apply to count two. Is that correct, Mr. Sneed?
Yes, that's my understanding, Judge.
And the embezzlement under count two carries a maximum penalty of up to 1 year in jail and a $2,000 fine, or up to 3 times the value of the amount embezzled. So, Mr. Amadeo, is that a correct recitation of the plea?
That is, Your Honor.
All right, and is your client going to avail herself of the plea today?
She is, Judge.
All right, Mr. Amadeo, will you be able to provide to your client the advice of rights and get that signed for us and sent back to us?
I will be able to do that today, Judge. I'm in the car right now in Lansing, but when I stop, I'll make sure you get that. And I did review her advice of rights with her as well.
Okay, all right, so Ms. Moran, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name for the record, please?
Jessica Lynn Moran.
All right, so Ms. Moran, I have read the plea agreement form that was provided to the court. And you heard the statement of your attorney and the prosecuting attorney concurring to that. So is it your intention to plead guilty to count 1, embezzlement, agent or trustee, 20,000 or more, but less than 50,000, which carries a maximum penalty? I'm sorry, this is a no contest. I misspoke. So is it your intention to plead no contest to count 1, embezzlement, agent or trustee, 20,000 or more, but less than 50? Yes
Yes, Your
or
Honor.
no? Okay. And is it your intention to plead no contest to count 2, embezzlement, agent or trustee, 200 or more, but less than 1,000?
Yes, Your Honor.
And Mr. Amadeo, I'm assuming this is based on civil liability.
Correct, Judge.
Okay. So ma'am, are you satisfied with Mr. Amadeo as your attorney and the advice that he has given you?
Yes, Your Honor.
Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court other than what is in the agreement. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Amadeo?
Yes, Your Honor.
And Ms. Moran, to your knowledge, is that correct?
Yes, Your Honor.
All right. If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Ma'am, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, ma'am?
No, Your Honor.
Right. So your options on this will be no contest or not guilty. Okay, Ms. Moran?
Okay.
All right. How do you plead to the charge that on or about October 26th of 2022 through September 25 of 2023 in the city of Morenci in the county of Lenawee that you did commit the offense listed in count 1, embezzlement, agent or trustee, 20,000 or more, but less than 50,000?
No contest.
And in count 2, embezzlement, agent or trustee, 200 or more, but less than 1,000?
No contest.
All right. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Amadeo,
No, Your Honor.
Mr. Sneed.
No, Your Honor.
Other than the plea agreement, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your
Ma'am.
Honor.
Is it your own choice to plead no contest?
Yes, Your Honor.
All right, I don't typically do this, but I did receive, somebody else gonna put the factual basis on. I did receive a police report, but I typically don't do that. I can scan through it real quick though.
Or I could put a factual basis if you need that, Judge.
All right, go ahead, Mr. Amadeo.
Thanks, Your Honor. This is according to police report incident number 014-004-153-23. The venue is Letaway County, 211 West Main Street, Morenci, Michigan, and that's Premier Bank. According to the police report, my client was a teller there. There was an audit done of drawers 2 and 6, where she was in charge. There was also an audit done of drawers 8 and 10. There was a shortage done. There was an investigation done. And accordingly, the total cash shortage over a time period of the investigation was $39,000 and $39,045. I believe that covers the allegation of the embezzlement and the venue, Judge.
Okay. And for the the same for the embezzlement as well?
That's correct, Your Honor.
Okay. All right, thank you. Anything to add, Mr. Steen?
No, thank you.
So based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about the time period of October 26 of 22 through September 25 of 23, Ms. Moran was the bank manager at Premier Bank, and her employment was terminated after it was discovered that some drawers that were not physically in existence at the bank but were funded from each vault, and it was determined that Ms. Moran had used her position and converted her own use funds in the amount of $39,000, I think you said $45, and her intent was, and she did not have consent to use those funds or take those funds, and her intent was to use them for her own use. I believe that satisfies count 1 and count 2. Mr. Sneen?
People are satisfied, Judge. Thank you.
Okay. And Miss Holly, we will send a copy of that. We have a copy of the police report. We'll send that over.
What was the
All right,
amount? There was an amount for Kiwanis. I missed that.
So that's part of the plea that she'll pay restitution to them. It was $5,055, and Morenci School PTO was $2,764.
Okay, thank you.
Okay. And Mr. Sneed, has court complied with MCR 6.302 B, C, and D?
Yes, thank you, Judge.
And Mr. Amadeo?
Yes, you have, Your Honor. Thank you.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent plea or competent counsel. I do find that she did commit offenses listed in count 1 and 2, and I accept that plea. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Obviously, there's a Killebrew agreement. The court will honor that, barring any violation. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Amadeo, the date that I am using for sentencing is December 19 at 8:15 in the morning. Are you available that day?
I'll make that work. Thank you, Judge.
All right. So Ms. Moran, in light of the fact there was a Killebrew agreement for no upfront jail, you can appear either in person or via Zoom. So how would you like to appear that day?
Zoom, please.
Okay. Now, I'm going to refer this matter to the probation department. So, Miss Holly, do you want a breakout room with her, or do you want me just to tell her to report tomorrow, or?
Yeah, I need a breakout because I need an address and stuff.
All right, so Miss Moran, in a minute, I'm gonna put you in a breakout room with Miss Holly, and she's gonna give you instructions. I'm reporting to the probation department. You're gonna have to come in, get a packet to fill out, and then they'll set up an interview with you. You entered a no contest plea, so you are not required to make any statement about the events that occurred, but be truthful with them about your background. They'll prepare a pre-sentence report. We will send a copy to Mr. Amadeo. He will review that with you before the day of sentencing. And then we will see you back here on December 19 at 8:15 in the morning. All right, Mr. Amadeo and Mr. Sneed, anything else?
No,
No,
nothing.
thank you,
Thank you, Your Honor.
Okay, all right. Thank you both. Thank you.
Thank you. Bye.
Thank you.
Thanks, Bill.
All right, Mr. Sala, is that your client?
Yes, sir.
Okay. You pronounce it Eanes?
Yes, ma'am.
All right, go stand by Mr. Sala. All right, this is in the matter of the people. Huh? Oh, sorry. Hold on, Miss Moran. I forgot about you guys. Let me open up a breakout room and pop you two in there. So Miss Moran and Miss Holly, there you go. Join the breakout room. Sorry. Thanks, Doug. All right, this is in the matter of the people of the state of Michigan versus Matthew Robert Eanes, file number 25-22407FH. I have Stanley Sala appearing on behalf of Mr. Eanes. He and his client are present in the courtroom. I have Isaac Sneed appearing on behalf of the people. This is the date and time scheduled for the first pretrial in this case. Mr. Sala, how would you like to proceed?
Your Honor, appreciate that. Thank you. And I would indicate that we had asked that the video recording device that was used in this case, it came up during the preliminary exam. I need to know what's going on with that. If in fact the officer took it in to have it analyzed, or it's been an indication they tried to, the victim tried to delete what was on that video, and whether they can retrieve it off of that video. And if the police department's not going to do anything with that, I would like to have the opportunity to have it examined.
All right, and that was requested through discovery. So Mr. Sneed.
Your Honor, I think an issue came up during the exam. I don't think it was requested during discovery. So if Mr. Sal wants to file a motion and enlighten me, I'd be happy to entertain it at this point.
So, Mr.
It is on the record at the preliminary exam.
Okay.
And he said, the officer said he could have it examined as well, but if he wants me to file a motion, I can certainly file.
I'm
Or
assuming
follow up with
you've
the
already done your-
officer.
So, Mr. Sala, perhaps a formal motion for discovery and then requesting that specifically. Okay.
In my original appearance, there was a request for all videos and all recorded devices. So there's a formal request in my original appearance and request for discovery. So I can redo it again, or I could probably have to file a motion and Mr. Sneed's asking for a motion.
All right, so in the response from the people, it does say a request for a copy of any dash cam body or video has been sent to the arresting agency. That was in the response from the prosecutor's office. So I guess
This is a
Mr.
video
Sneed.
from the victim took.
Yeah, so maybe a specific request for that as well. Okay. All right, how far out would you like another pretrial, Mr. Sala?
Probably a month.
A month, okay. Are you available on December 3rd or December 10th? And Ms. Adams, I'll need a notice of hearing.
Yeah.
It'd be at 8:30.
I believe I have a divorce trial here at 10:30, so.
So you're here which day? Which day, Mr. Sullivan?
That's December 3rd.
Okay, so we'll set this for December 3rd at 8:30. Of course, you can do it via Zoom if you don't want to come that early for your divorce trial. Ms. Adams, if I can get a notice of hearing from Mr. Sala and Mr. Eames. All right, so have a seat right behind you on that bench, Mr. Eames, and we'll get you a notice, okay? All right, thank you. Okay, so, all right, who do I have from MDOC, please?
Eric Maddox.
All right. Let me get you. All right, I'm gonna change your screen name. And where are you currently residing?
I'm on call.
Okay. Eric Maddox. All right, so we, it's MADDOX.
Yes, ma'am.
Okay, so Mr. Glazier is your attorney. Mr. Glazier goes to the judge next door first and then comes to my courtroom. So he will just be a few minutes. So if you want to just hang out with us for a minute, we'll take you when he gets here, okay?
All right.
All right, thank you. Mr. Stewart, you're all set if you want to log off. Or Mr. Malaro was, okay.
Yes, Your Honor.
Iagully, Angelo Iagully. Hi, you want to come up
He's
to the podium?
Oh,
He's
he's
here.
here. Good. All right. Got my
here.
message. Good for him.
He's got his safety yellow on, can't miss him. All right. Nope, stand right at the podium, and it's Iagully, right? All right, so this is in the matter of the people of the state of Michigan versus Angelo Craig Iagully, file number 25-22412FH. This is the date and time set for a first pretrial conference in this matter. I have Salvatore Malaro appearing on behalf of Mr. Iagully, and Mr. Banetto, this is your file?
It is, Your Honor, yes.
So, Mr. Malaro, how would you like to proceed today?
Your Honor, I would ask to adjourn the matter. Mr. Iagully dropped off some records or documents for me to look at, but I was a little preoccupied with the events of last week and earlier this week. I haven't had a chance to review them, so that is the basis for my request.
Okay. Has there been a plea offer made in this file, Mr. Banetto?
Probably.
There is, Your Honor. It's plea to count two as charged. Mr. Iagully also has a few district court cases pending. The offer would include a plea as charged to case number 251416 SD in the district court, and then all remaining counts and all remaining cases in district court will be dismissed.
What's that district court file plea to? What is the charge?
It is an OWI second offense, Your Honor.
Okay. So is it Iagully or Iagully?
It's Iagully.
I thought so. All right. So Mr. Iagully, the plea offer, as your attorney's probably told you, is you have count two, an aggravated assault misdemeanor. It would be plead to that misdemeanor, and they dismiss the police officer R&O felony, and then an OWI 2 in district court, which is also a 1-year misdemeanor. So how far out do you want a pretrial, Mr. Malaro?
Judge, I don't need very long. Probably the 26th would work of November.
All right. So Ms. Adams, could I get a notice for him for November 26th at 8:30 in the morning?
Yes, Judge.
So Mr. Iagully, have a seat right behind you. Yep, right there. And we will get you a notice of hearing and you can be on your way back to work, okay? All right, thank you.
Thank you, Judge.
Thank you, Mr. Malaro. I think you're all set. All right, Mr. Dagger Margozzi. You have Timothy Neves. So I have a jail room 4. I don't have audio and I don't have video.
Good morning.
Good morning. Hi, I have jail room 4, but they don't have video.
So the video is one moment, ma'am.
Okay, thank you.
Thank you.
Have a good day.
I have one question.
Sure.
Do I still have the 15 on the?
If you have a district court case, you have to appear for those dates too. So make sure you go to district court in here. If you have any questions, call Mr. Malaro's office. But yeah, we're 2 different courts. So if you got a date on the 15 downstairs, you better show up so they don't issue a warrant, all right?
Oh, definitely. Thank you.
All right. Nope, right there. Back up. Yep, there you go. Mr. Neves, I'm gonna send you a request again, start video, maybe that'll work.
Yep.
All right, I think it's just there we go, okay. So do you pronounce it Neves?
Yes, ma'am.
All right, so this is in the matter of the people of the state of Michigan versus Timothy Jerome Neves, file number 25-22222 FC. I have Michael Dagger Margosian appearing on behalf of Mr. Neves, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for, I think, like the 3rd pretrial in this matter. So, Mr. Dagger Margosian, where do we stand at this time?
Your Honor, may I speak with Mr. Neves? Ultimately, we're going to be setting it for trial, but may I just speak with Mr. Neves, please?
Yep. What is that plea offer in this file?
As charged.
Okay. Oh. All right, so I'm going to open up a breakout room, and Mr. Neves, you'll get an invitation to join it.
Okay.
Find it. And go ahead and join it. Mr. Malaro, I don't think I have anything else for you, do I?
I don't think so, Judge. If you're telling me to get lost, okay, I can take a hint.
I don't know. I thought maybe you were monitoring me or something, but David McFarland
No, I'm not
does that in
monitoring
front
you,
of the
Your
court.
Honor.
Okay.
There's plenty other people, I'm sure, in the county doing that.
Well, I know. Well, now that your murder trial's off, I figured you got lots of time.
Just a lot of time filled. No
I
break
know.
for me.
I know.
All right, thank you, Your
All right.
Honor.
Thank you. Sir, is there an Edwin Sanchez in the courtroom? No. Mr. Sanchez?
Yes.
Okay. Your attorney will just be a few minutes.
Okay.
Okay. He's next door. And you're Rhonda. So Rhonda is next door, and Eric Maddox. I got Mr. Frazier. Mr. Maddox, I have Mr. Glazier, so we will take your file, okay?
All right.
All right, Mr. Glazier, this is in the matter of the people of the state of Michigan versus Eric Dominic Maddox, file number 25-22438FH. I have John Glazier appearing on behalf of Mr. Maddox. Are you with us, Mr. Glazier?
Yes,
Okay, and Mr. Bandetto, this is your file?
It is, Your Honor, yes.
Okay, and Mr. Maddox is joining us from the Macomb facility. So this is the date and time set for a first pretrial conference in this matter. Has there been a plea offer made on this file?
there has, Your Honor. I think it is plead to count, let me double check. Plead to count 1 and count 2 would be dismissed.
Okay, let's see what that is. All right, so plead to count 1 and count 2 would be dismissed. So count 1 is a high court misdemeanor. It carries a maximum penalty of up to 2 years. And the other one is 1 year to life. So typically on these MDOC cases, sentence at the low end of the guidelines. So Mr. Glazier, how would you like to proceed today?
Maybe I just need to speak with Mr. Maddox. I talked to him once before and I thought he wanted to take the plea, but I'm not sure.
Okay, so Mr. Maddox, what it means is when they calculate your guidelines, I will sentence at the low end of the guidelines, all right?
All right.
Okay.
Mr. Maddox, we discussed this before. Do you want to plead to the?
I'm gonna put you in a breakout room, Mr. Glazier, hold on.
All right.
So Mr. Maddox, I'm going to put you in a breakout room. Let's see if you go automatically. Yep, he did. Mr. Glazier, let me find you. And go ahead and join that breakout room. Mr. Bayonetto, I'm assuming there's no habitual offender either. There isn't one on the felony information, but he's obviously in prison, so he must have a prior felony.
Correct, Your Honor. Okay.
I just wanted to check.
The offer would have been to dismiss that anyway.
Yeah. All right, so. Wait. Checking my mannequin. Okay, Mr. Glazier, let me bring your client back. All right, we are back on the record with Mr. Maddox. Mr. Glazier, how would you like to proceed?
Your Honor, he's going to plead to the aggravated indecent exposure with the understanding a sexually delinquent person would be dismissed. I don't know if there'd be the SUPs would be dismissed too. I don't know if there are SUPs.
We
There are no
didn't include
subs,
any
but
subs on
they
this
would
one.
have been dismissed. That's part of the agreement. I already checked on that. Thank you.
Okay.
All right, so Mr. Maddox, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I affirm.
Okay, do you swear, yes or no?
Yeah, I solemnly swear, yeah.
Okay, thank you. We kind of lost the audio on that. So, Mr. Maddox, you heard myself, your attorney, and the prosecuting attorney. Is it your intention then to plead today to count one, aggravated indecent exposure, which is considered a high court misdemeanor and carries a maximum penalty of up to 2 years in prison, with count 2, as well as any habitual offender notice being dismissed? So is it your intention to plead guilty to that?
Yes, ma'am.
Are you satisfied with your attorney and the advice that he has given you?
Yes, ma'am.
Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court, although the court did state that they would sentence at the low end of the guidelines. Is that correct, Mr. Glazier?
Yes, Your Honor.
Mr. Bayonetto?
Yes, Your Honor.
And Mr. Maddox, is that correct as far as you're aware?
Yes, ma'am.
All right, so if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be made by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
All right. Do you understand that if plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, which we don't have to worry about, violating terms of conditions on bonds or term of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So in your case, if you were to catch a new charge, that could be a violation of that. Do you understand that?
Yes, ma'am.
Okay, if you are not a US citizen or a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. And let me see, this is, so this is tier 1 offense if the victim is a minor, so no. It is a tier 2 if they have a prior conviction for a tier 2. So because I don't have any habitual offender notice, Mr. Bayonetto, does he have a prior conviction for a tier 2 offense or any prior CSC convictions?
He does have a prior tier 2 conviction, Your Honor, for aggravated indecent exposure. He has 2 of them.
Okay, so, all right, it is a tier, okay. So in this case, it is a tier 2 if they have a prior conviction for tier 1. It is a tier 3 offense if the defendant has a prior conviction for tier 2. Let me get there. So it's a tier 3 offense and he has a prior tier 2. So, so are you already required to register Mr. Maddox as a sex offender?
Yes, ma'am.
Okay, so this would be a tier 3, which means that you have to verify your residence and personal information in person 4 times a year for life and to be listed in the public registry. Do you understand that?
Yes, ma'am.
And I think you're already required to do that, correct?
Yes, ma'am.
Okay, so you understand this also requires that.
Yes, ma'am.
Okay, do you have any questions about the rights that I've given to you, Mr. Maddox?
No, ma'am.
All right, so Mr. Maddox, how do you wish to plead to the charge that on or about July 11 of 2025 in the city of Adrian in the county of Lenawee, that, was this at Gus Harrison then, Mr. Banetto?
It was, Your Honor.
All right, that you did commit the offense listed under count 1, aggravated indecent exposure. Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the defense counsel or prosecutor aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier,
No, Your Honor.
Mr. Banetto.
No, Your Honor.
Other than me stating on the record that I would sentence you to the low end of the guidelines, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, ma'am.
Okay, is it your own choice to plead guilty?
Yes, ma'am.
Okay, so, Mr. Maddox, on July 11 of 2025, were you at the Gus Harrison Department of Corrections facility located in the city of Adrian in the county of Lenawee?
Yes, ma'am.
Okay, and so at that time, when you were in a public area, did you take your genitals out and fondle them in public?
I was in the shower. I wasn't in public, but yes, ma'am.
Mr. Banetto, help me out here.
I apologize, Your Honor. I closed out the report. The incident that is being described, Mr. Maddox, were you in therapy room 185 around 10:30 on July 29th of 2025?
Oh, yes, sir.
And at that time, while you were in the therapy room, did you have your penis out and were you fondling your penis in front of Corrections Officer Babiak?
No, sir.
But that's a different day. I have July 11 on my felony information.
I apologize. It is July 11th. The report was on July 29th. But the incident that is being there were multiple incidents. One was in the shower, yes. The other was in the therapy room. So if
Mr. Maddox, did you expose yourself in the therapy room?
No, not in the therapy room. No, ma'am.
Okay. Did you expose yourself? Well, obviously in the shower. Did you fondle yourself in the shower? Were there other people there?
Yes, ma'am.
And Mr. Maddox, at that time, was there also a nurse in the shower area at the same time as you?
Not in the shower area. She was conducting unit rounds.
Your Honor,
Did you did you take your genitalia out and touch it while she was around?
Yes, ma'am.
Are you satisfied, Mr. Glazier?
Yes, Your Honor.
Mr. Banetto?
I'd be satisfied, Your Honor.
Okay. 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 All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Glazier?
Yes, Your Honor.
Mr. Banetto?
It has, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Glazier, are you available for sentencing on December 19 at 8:15?
December, did you say?
Yes, sir. Yep, December 19.
Yes, yeah, I'm available. I'm always available.
Okay, so we will set this for sentencing on December 19 at 8:30 in the morning. So, Mr. Maddox, you do have the right to come in person for sentencing, or you can appear via Zoom. I know you're in Macomb and we need fingerprints, don't we, Miss Adams? I have a note.
Yes, it appears we do not have prints.
All right, so Mr. Maddox, unless they get fingerprints on you, I'm gonna set this in person because I can't sentence you without fingerprints, and I don't know why they haven't gotten fingerprints from you because you can't really go anywhere and it's the Michigan State Police. So I'm gonna set it in person, and hopefully maybe we'll do an order for fingerprints and send it to the state police, and maybe they'll come fingerprint you. But if they fingerprint you in advance, do you want to appear via Zoom or in person?
In person.
Okay, we will leave it in person. All right, so we will see you back on December 19 at 8:30 in the morning. Someone from the Michigan Department of Corrections will speak with you, do an update to their pre-sentence report. We will send a copy of that to Mr. Glazier to review with you, and we'll see you back on that day, all right?
All right, thank you.
Thank you.
Can I talk to my attorney, Mr. Glazer? Can I talk to you for a second?
Sure, if the judge will put me in a room with you.
Yep, I will do that real quick. Okay, go ahead and join the breakout room. All right, so we are back to you, Mr. Degemer goes in. Follow it is, oh, Mr. Neves. So, Mr. Degemer goes in. How do you want to proceed today?
Your Honor, I'm asking the court to set this for a trial. I'd ask it to be a bench trial here.
All right, so. One day?
I think so, yeah.
An hour and a
Your Honor, I
half.
apologize. I was not prepared for a bench trial request. I think it may be longer than just a day.
Oh, you know what? I'm sorry. I was looking at the wrong file. So this is assault with intent to murder and unlawful driving away of a motor vehicle. There is no plea offer. Is that correct at all?
Your Honor, the offer would be as charged with a stipulation to a sentence within guideline range. I just took this file over yesterday, so I'm not sure what the guideline range Mr. Dagger-Margosian calculated was, but I know Ms. Wise had run the guidelines, and I don't think that they lined up with what Mr. Dagger-Margosian had.
All right, so I see at least 20 witnesses listed by the people, only 3 raised. Just let's take this book. How many days do you think then, Mr. Bandetto?
Your Honor,
And you agreed?
I think
a week.
Three
Okay.
to be safe, given the amount of witnesses I'm looking at. I don't know. Your Honor, if you want to set it for 2, that's fine.
So
like I said,
do you agree to a bench trial, Mr. Bandetto?
I'm fine with a bench trial, yes.
Okay. All right, so. Two. Let's see. Okay. So I obviously won't have anything this year because we're at the end of the year. So I do know that Judge Olsaver has a 3-week, 4-week, 5-week, 6-week, I don't know, jury trial at the end of January. You're not on that file though, Mr. Vando, correct?
Correct, Your Honor.
Okay. So I don't want to start mine the same week as Judge Olsaver's because I can.
Your Honor, just, I don't know if the court's aware, if the Judge Olsaver's court in that file had set, I think, 2 weeks for jury selection. So if the court wanted to avoid that, maybe the first 2 weeks of that trial.
He is in custody. So I am looking at 16. She's not in jail. Oops. I'm gone.
Your Honor, if I could suggest sometime in February might make sense. Mr. Neves has an OWI case downstairs, and that's going to be pled to tomorrow, and there's going to be a jail sentence on that. So, however that factors into the court's scheduling is fine.
Right, so I can start this. We're gonna have some overlap. I can't imagine that it's gonna take 2 weeks for jury selection. I really don't. Just really don't. So I am looking at, because I'm gone the first week of March, I'm looking at Tuesday, February 3rd at 9 a.m. That'll give Judge Olsaver a week, I think. What day does his trial start down there?
The 27th is day one, is what I see.
That gives him a week. Okay, February 3rd at 9 a.m.
That works for the people.
Mr. Degermar goes in.
I'm going to be unavailable on the 2nd, so I would be getting back on the 3rd. It's just a little tight. Is there a different day?
February 4.
Yeah, that's perfect.
Okay. All right, that would be a 10:30 start date, so we could spend first day on jury selection. Okay.
Judge's bench.
Bench trial, Your Honor.
Oh, shoot, that's right. To do all the work. Okay. All right. Bench trial. All right, we are going to set a final pretrial for January 21. At 8:30 in the morning. And I will set that as motion deadline. Are you here that week? Mr. Degermar goes in?
Yes, thank you.
Okay. We don't need jury instructions. We don't need voir dire questions. I don't do pre-agreement deadlines. So I'm going to sign this and get a copy out to everybody. Obviously, if you need a bench conference or anything like that, you can set that up. All right, I filled out a scheduling order, and I see that the transcript's done. So, all right, we will see you back on that day, and thank you very much. I'll get a copy of this out to everybody. Thank you.
Okay.
Thank you, Your Honor.
Thank you, Mr. Neves.
Thank you. You have a good day.
You too.
Yes, ma'am.
Okay, so bring Mr. Maddox back. Mr. Sanchez? Edwin Sanchez?
Yeah.
You want to come up?
Just him, sir.
I think he's interpreting. Are you interpreting for him?
Yes.
All All right, so I have to request for all future hearing dates that we have a certified one. I apologize, I know that, but we're just required by law.
That's fine. I was asked by the public defender.
Oh,
The
We always have an interpreter there, Your Honor.
I've never had one show up in my court because we always were required to do it, but that's fine. So
Yeah, the
this
reason-
is
the rea-
in the matter. Hold
The
on.
reason, I was gonna
This-
tell you, the reason
Hold
we
on,
do.
John, hold on, let
Okay.
me call the case, please. This is in the matter of the people of the state of Michigan versus Edwin Sanchez.
Judge, I need advice.
Yeah, so here's the deal. Mr. Glazier, I appreciate that you're accommodating us this way. We are required to have one through the court and it has to be audible. So, sir, you have to speak loud enough that, because we record everything in the courts. So it has to, when you interpret it, has to be loud enough and I have to swear you in. Are you a certified translator?
No, I'm not.
Okay, so Mr. Glazier, he's not certified
If
and I
could-
appreciate,
I was gonna explain, Your Honor, but you didn't let me.
right?
We always have an interpreter available. He does not have to be certified. The reason we have an interpreter available is if we have to have a private conversation with our client. He's not there to interpret for the court. He's there to interpret in case we have to have a one-on-one with our client. And we don't want the court interpreter to be doing it.
So Mr. Glazier, we weren't made aware that your client needed an interpreter. So I'm going to adjourn this to get a certified interpreter because I can't proceed on the record without a certified one. And I appreciate the job that you do. That's great. But Mr. Glazier, so I'm gonna put in a request.
Yeah, there was a certified interpreter down at district court, Your Honor. So I don't know why it
Right,
wasn't.
but we didn't get the request. So
Okay.
Miss Adams, I need to adjourn this. How much time do you need for a certified translator?
Judge, I would say 2 weeks is sufficient.
So if I could get a notice of hearing for, let's do November 26th. Yeah, thank you. You got his name?
Yes, Judge.
Okay. What's his name? All right, Olivero Garza Jr., thank you. And no offense to you, we just have to, in a court proceeding, have a certified. All right, so I'm going to adjourn this to November 26th at 8:30 in the morning, and we will do a request for a translator, and they appear via Zoom. And then I'll get your client a notice of hearing, Ms. Adams, if we can get that from Mr. Sanchez. And have a seat behind you. Yep, thank you. All right. Okay, so. All right, Ms. Betts, we're waiting on Rhonda Underwood. That's Sarah Brenner. Terms empty. Hi, Ms. Brenner. We are waiting for Rhonda Underwood.
Morning, Judge.
And yeah, Ms. Betts.
We need to have our interpreter there too on that date.
Yeah, you can always have your interpreter here. He just can't go
Okay.
on the record.
Yeah, you know you have to be there. Okay.
Ms. Adams, could we get a notice, an extra copy for him, the translator too? All right, set that one for trial. All right, Mr. Glazier, I don't think I have anything else for you.
No, that's all I have. Thank you, Your Honor.
All right, thank you. All right, so you got, you're good. All right, thank you.
Thank you.
Thank you.
Okay, they both get one. No, they didn't both get one.
Huh?
They didn't both get one. John wanted to.
Sir, Mr. Garza, if you want a copy of the notice, we'll get you one. Sure. You got one for him, but we will get you one. I think Becky's gonna, Miss Adams will bring it in now. Hey, this is Judge Anselone. You have a Maria Rodriguez.
Yeah,
Could I see her?
of course. You can get her in.
All right, thank you. Bye. Sir, what are you here on?
Sorry?
You have a case?
Yes, no, ma'am, I do not have a case before the court, ma'am. I'm sent here regarding a civil matter. One of the witnesses in our case is Ms. Holly Schmidt, who's supposed to.
That case was adjourned.
Oh,
I'm sorry. I don't know when it was adjourned to.
I believe it's December 7th.
We think it's December 7th. Sorry about that. Okay. 17th, I'm sorry. All right, Miss Underwood, I have Miss Betts.
Okay, Your Honor, we can start with.
Okay, this is in the matter of the people of the state of Michigan versus Julia Betts. So Julia, come on up to the podium. If you call like the day before to verify whether it's going or not.
okay.
Okay,
Thank you.
thank you. So in Miss Betts, this is file number 22-21100FH, 23-21264FH, 23-21519FH. I have Brenda Underwood appearing on behalf of Miss Betts. I do have a report from Darren Coast saying Miss Betts has done well with a remote breath testing. Her last 21 blows are on time and all 0.000 BAC. He would like to adjourn her contempt of court out. And then I think there was some district court things. So Miss Underwood, how do you want to proceed today?
Well, I think Ms. Betts, am I correct that the matter in district court was dismissed?
Yes.
And I tried to get a hold of Ms. Teskey to talk to her, Your Honor, but I was not, my calls would not return. So, so I guess we can adjourn it out, Your Honor.
Yep, I understand that these charges may have been dismissed, but the other violation is for consumption of alcohol.
That's correct. But I was unable to discuss that with Ms. Teskey.
Let's see.
Regarding the other charge.
All right, let me see if Sarah is here today. Sarah. All right, have a seat right behind you and I'm gonna try to get Sarah Teskey, all right? All right, so while we're waiting, Miss Underwood, I'm gonna arraign Miss Rodriguez. Okay. This is in the matter of the people of the state of Michigan versus Maria Rebecca Rodriguez, file number 24-21897FH. I have Ms. Rodriguez appearing via Zoom from the jail. So Ms. Rodriguez, we are here today on a request and warrant for probation violation. These are non-technical violations. It is alleged that you have violated the terms of your probation and that you have been charged with financial transaction device possession with an offense date of June 30th, 25. Count 2, all right, so basically not to violate any, wait, are there 2? Oh, and then count 2 is that you were charged with financial transaction device stealing, retaining without consent, and then also computers using to commit a crime. So the allegation is that you violated state law or governmental law by committing 3 new criminal offenses, which I'm assuming you are going to be arraigned on either today or tomorrow. Ms. Underwood, you might have more information on that. And so you are currently on probation for controlled substance possession of cocaine which carries a maximum penalty of up to 4 years in prison. So Ms. Underwood is here if you want a court-appointed attorney. So Ms. Rodriguez, would you like a court-appointed attorney?
Yes, please.
All right.
Yes, Your Honor.
So Ms. Underwood, I'm gonna pop you into a breakout room. But hold on a second, before we proceed with that, Ms. Underwood, I have Ms. Brenner here in the matter of the people of the state of Michigan versus Michael Robert Newsome, file number 24-22068FH. I have Ron Underwood on behalf of Mr. Newsome and Sarah Brenner appearing on behalf of the people. So, Ms. Underwood, Mr. Newsome is not here. Is he making payments or doing anything?
Yes, Judge, he's making steady
payments, Your Honor.
Yeah.
He's doing very well.
All right, so why don't I set this out in light of that? And Ms. Underwood, you need to make sure you get a hold of him and let him know his next court date. Obviously, he can Zoom. So why don't I set this out for January 7 at 8:30 in the morning?
And
That works,
I will
Judge.
be happy to do the stip and order with Ms. Brenner's permission.
That's fine.
Okay,
Thank you.
great. All right, so Ms.
Thank you,
Brenner,
Anna.
thank you. And thank you. Have a good day.
You too.
All right. That way that one's taken care of. Okay, now I'm gonna open up the breakout room. And Ms. Rodriguez, I'm gonna pop you and Ms. Underwood into that breakout room.
Thank you.
You're welcome.
Judge, is Kevin Reichner going?
Who?
Kevin Reichner, it's Castleberry's case.
That's at 10:30.
Oh,
We had it on wrong. It's got a bench conference at 10:30. I'm sorry.
that's okay. If I guess, okay.
Judge, it was originally a pretrial and they changed it yesterday to a bench conference.
Oh,
Okay.
so you don't need me on that one.
Probably not. And then I think I just have Miss Betts on a violation of probation.
Yep.
Miss Rodriguez, and then I think I'm done with you.
Yep.
Not that I want to be done with you, but then I'm done with you.
Right.
So I don't know if you need to stay on the box or not.
Yeah, there's nobody here yet. Yeah.
I don't know if she's here. I don't know if she's like virtually here in the building here. All right, I am gonna close that breakout room. I already know what you're gonna say, so bring her back. All right, so Miss Underwood, you've had a chance to speak with Miss Rodriguez.
Yes, I have, Your Honor. And Your Honor, we would ask the court to enter a not guilty plea on this violation. And we would ask the court to set it out a couple weeks to give the underlying felony charges a chance to proceed in district court. Your Honor, my client claims she has proof of innocence in this matter. She intends to vigorously defend it. What I would ask, Your Honor, is that Ms. Rodriguez works at Taco Bell. She's doing very well. These charges are from June, and they're financial in nature, Your Honor. They aren't violent in any way. I would ask the court to give Ms. Rodriguez a PR bond in this matter Your Honor, because I don't know that they're going to keep her downstairs either. And I would like her out working and proceeding to defend these matters, Your Honor. She has stable housing and she does have employment.
Okay, so this is, so we had a violation in July. We had a violation of bond conditions, on a prior offense. Miss Holly, this is a Miss Walsh file. Do you know if Miss Walsh is in the building?
She is, she is, but she's got, I think she's in the other court. She emailed me about this case, said she did not have a position on bond.
Okay, really? Okay. All right. So, Miss Rodriguez, let me tell you this, all right? This is not your first violation, okay? And you potentially could be facing a lengthy jail or prison term. So if I release you on a pure bond, understand, I don't want any nonsense. You behave, you report, you follow through with district court, and you don't give anybody any issues. You go to work, you pay your fines, you better start paying on your fines and costs. So I will give you a PR bond, and Miss Underwood, I will set this out to December 10 at 8:30 in the morning, and that might be enough time to see what's going on in district court. Those are all felony charges. So make sure when you get out, you call Miss Walsh and you report as you're required to. You understand?
Okay, thank you.
All right, so
That is what she asked, that she call her as soon as she gets out.
Yep.
Yep, thank
All
you.
right, thank you. You're all set.
Thank you. Have a good day.
All right, Miss Tusky.
She's in the waiting room.
Oh, she's in.
Oh, okay.
She's just probably busy in another court. Becky, if you want to call Mr. Castleberry, and let me see, who's the prosecutor on that one? I could probably do their bench conference a little early. Trying to think, I think it's Phoebe McClure.
Yes.
All right. Sarah Tusky. She's ignoring me. She does that a lot. I just dropped the files.
Do you need any to go to Becky?
These can go to Becky. I just have these two. And she can take these. Oh. Isaac's name, I think you're all set, aren't you? You're muted.
Had something on the calendar for Cody Lowe, 9:30. That get taken off by chance?
Not me, but it might be in district court. Didn't he have something in district court? I don't know. I don't have him today.
Cody Lowe was adjourned to 11:19.
All right, thanks, Josh.
Thank you. All right, so Miss Teskey, we are here on Miss Betts. And Miss Teskey, I think Miss Underwood was inquiring as to, since the new charges in district court were dismissed, were you willing to amend where it's, the violation is simply for consumption of alcohol?
Yes, Your Honor. I don't believe that we should just completely dismiss this. She's had several instances of drinking and domestic violence in the past 6 months, and we have dismissed all of those. And I don't believe that this should just be dismissed because they dismissed the DV.
So are you fine with dismissing allegation 2 and just proceeding on allegation 1 for testing positive for alcohol and the police being called to her home?
Yes.
All right, Ms. Underwood, do you want a moment to chat with
thank you.
Ms. Betts? All right, so Ms. Betts, I want you to go in the hallway. And that device is already connected. And I'm gonna put you and Miss Underwood in a breakout room, all right? All right, Ms. Betts, you're gonna get an invitation to join the breakout room.
Okay, now I'm gonna leave.
Okay, now you can go. Thank you.
Okay, thank you.
Just testing where my boot is.
So you can see.
No, I don't. She's cleaning the piano. She's dusting the piano. Today's a clean day. Hey.
I didn't know you were on the pitch. Sorry.
Who's your prosecutor?
Phoebe.
Phoebe. Yep, come back in. All right. All right, so Miss Underwood, we are back with Miss Betts. And Ms. Teskey, just for your information, Darren Coast did provide a letter stating that Ms. Betts is doing wonderfully. Her last 21 blood alcohol tests were completely negative, and he had no objection to moving out the contempt of court. Mr. Coast, if she ends up pleading to the violation of probation, do you care what happens with your contempt?
I don't, Judge.
Okay. All right. So, Ms. Underwood, now that I've bargained your case down, how would you like to proceed?
Your Honor, in all fairness, I would have done that myself had I.
I
had
know
the
you would have. You
opportunity.
always do, but I brought it in.
Yes, Ms. Betts will plead to count 1, count 2 having been dismissed.
All right, and that's on each file, right?
Yes, correct, Your Honor.
So Ms. Betts, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so Ms. Betts, you have heard Ms. Teskey and Ms. Underwood and everyone. So Ms. Teskey is going to dismiss the second allegation on your violation of probation. And we're going to proceed only on the one that on December 15 of 2023, you were ordered not to use any alcohol and that you violated or committed a technical probation violation for testing positive for alcohol on September 26th of 25, when the police were called to your home for an alleged domestic and you had a 0.185 BAC. So do you understand that's a charge against you on each of your files?
Yes.
On file number 23-212164, you're currently on probation for attempted possession of methamphetamine which carries maximum penalty of up to, I believe it's 2.5 years. Wait, let me double check. I did something weird. Let's see, I should have a felony information that was amended. Let me find it. Where this is violations. I think it's attempted a 5-year, Ms. Teskey.
Yes, Your Honor.
Possession. Okay. Some probation officers are really nice and put that in there for me, so I don't have to search through the file, but it's okay. And then
I'm
on
sorry.
file number 23-21519 FH, you're currently on probation for what? You're currently on probation for, let me get there. Uttering and publishing, which carries a maximum penalty of up to 14 years in prison. Do you understand that?
Yes.
Okay. And then on file number 22-21100 FH, you're currently on probation for larceny 1,000 or more, but less than 20,000, which carries a maximum penalty of up to 5 years in prison. Do you understand that?
Yes.
All right. So Ms. Betts, you've had ample time to speak to your attorney.
Yes.
Are you speak up a little bit?
Yes.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes.
All right, Ms. Betts, is it your intention then today to plead guilty to count 1 on the violation of probation on each of these files?
Yes.
All right. Now, did I swear in this thing?
You did. Yes.
Okay. So do you understand that you have a right to contest the violation of probation charge and to have a trial on it?
Yes.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
How do you plead to the charge that you violated the terms of your probation by testing positive for alcohol on September 26th of 2025 and having a 0.185 BAC? Guilty or not guilty?
Guilty.
All right. Has anything been promised to you to get you to plead guilty?
No.
Do you understand that by pleading guilty, you're giving up your right to a trial?
Yes.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
All right, so Ms. Betts, you were placed on probation on all of these files, and one of the terms of your probation was you were ordered not to use alcohol. Is that correct?
Yes.
And on September 26th of 2025, had you consumed alcohol?
Yes.
And when you had a blood alcohol content test, would you agree it was a 0.185?
Yes.
Well over double the legal limit.
Yes.
But, and okay, and what did you drink? Drink.
Twisted teas.
Okay, those are pretty wicked, right?
Yeah.
Oh, yeah. All right, so Ms. Betts, okay, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation, and I am going to set this out December 19 at 8:15 in the morning. Are you available that day, Ms. Underwood?
I think so, Your Honor.
All right, so I'm going to set this out. Could I get a notice of hearing for sentencing for Ms. Betts, Ms. Adams?
Okay. In person?
In person?
Yeah.
Yes, please. So Ms. Betts, you know, you're in recovery court.
Yes.
You've done a good job on that. This isn't uncommon that people substitute something else. This is not the life you get to lead. Like, I know your friends are partying and having a good time, but you have a hell of a lot more to risk than they do, right?
Yeah.
So what happens if you go to prison to your baby?
I lose her.
Yep. And dad gets her and has custody, and then you got to come out and fight to get custody. Is it worth it just to get drunk and have a good time? You don't, because of the stuff you were involved in, you don't get those options anymore, right?
Yes.
And it sucks and it's part of life because you're young and you want to have a good time. But when you do those things, bad things happen. Okay?
Yes.
So I don't want any more of this. You understand?
Yes.
All right, so we'll set that for sentencing. And Ms. Teskey, any instructions?
No, Your Honor, she's reporting to me and everything's, she just needs to
Do you wa-
continue doing what she's doing.
Do you want her still doing the remote testing as well?
That was a condition of bond, so yes, until sentencing at least.
Okay, all right, so no more. You think long and hard about it. And then I'll see you tomorrow at recovery court, okay? All right, thank you, Ms. Underwood.
Oh.
And then I'll dismiss the contempt of court at sentencing, all right, Ms. Underwood?
Thank you, Your Honor.
All right, thank you all.
Oh, and Your Honor,
Yes, ma'am.
I didn't mean to tattle on anyone yesterday.
Oh, yeah, he's grounded. Yeah. We're in no fast food home, so he's in big trouble. I think he might have been cursing your name a little bit last night.
I'm so sorry. Now snitches get stitches, you know.
I know, right? They do. All right, you have a good night. Thanks, Rhonda.